This act we have already done. First thing we have done, first paragraph. This is your second chapter. This is your third chapter we have done. And this is fourth chapter we have done. Okay, so now let's start with the fifth chapter. Okay, this thing we have to done. Fifth one. So what is written? So class, the Central Registry of Securitization Assets Reconstruction Company, that is CERSAI, okay, under SURFACE was set up by central government. Okay, so we can say that the CERSAI set up by central government on March 2011. CERSAI shall be maintaining and operating the central registry for on behalf of the this one. So we can say that this is the work of your CERSAI. This is the work of your class, what? CERSAI. Okay, so I'm telling you the exact way of CERSAI. Suppose this is X person and this is bank, right? So we know that, okay, when bank will give loan to the X person, suppose 15 lakh, in this case X person will give the security to the bank, right? So this is your what? Security. So this security bank have to be what? Registered. Bank have to be registered. So in what way? So the bank have to be registered so that you can easily say the borrower cannot use that property in the another loan. So this is the basic theme. So who will register? The CERSAI Act is there under which the property shall be registered. So this is very important. Is that okay? At present, the particular of transactions charges required to be filed with CERSAI by bank and financial institution. Okay, the charges will be effective from the date of registration of charge with CERSAI. Registration under other applicable law will continue. All transactions and creation of security interest need to be noted. Modification and satisfaction also need noting in prescribed form with the payment of fees and within the stipulated time. So we know that we need a registration because the process is very, very simple. Now tell me the right answer. After coming into operation, the provision relating to central registry, the bank and financial institution will have to register all security interest created in the assets. That is true and false. Yes, class, tell me. After coming into operation, the provision relating to the central registry, it means we are talking about the CERSAI. The bank and financial institution will have to register all security interests created in the assets. Tell me, class, this is right or wrong? So in that case, the right answer is absolutely right. Okay, this is absolutely right. True. Okay. The period stipulated in the Act for recording the satisfaction of security interest is the dash days from the date of such payment and satisfaction. This is important one. This is class important one. The period that is stipulated in the Act, right, for recording the satisfaction of security interest is dash days from the date of such payment and satisfaction. So under this case, the right answer will be 30 days. Okay, the right answer will be 30 days is the right answer. Duty to report satisfaction of charge to the central registrar is on creditor or on the borrower? Tell me. Creditor means the person who will give money. Borrower, sorry, creditor to whom? In simply whatever diagram I have tell you, so the registration have to be done by the bank or this borrower. Tell me, class. That is very simple. That is very simple. The right answer will be creditor. That is a bank and financial institution. Okay. Beside the CAIIB Act, some other laws require some registration of charge created in the property. So is such double registration is avoidable? Double registration is class avoidable. Tell me. The question is very simple. Beside the CAIIB Act, some other laws required some registration of charge created in the property. Is such double registration avoidable? Yes, the creditor can choose under which law he needs to be registration. No, registration under CAIIB Act as well as any other applicable law will have to be made, as the CAIIB Act is not substitution of any other law. This is absolutely right. B will be the right answer for this question, class. B. Okay? B is the right answer. Next. Next question, as you can easily see that. Okay. Contravention, attempt to contravene or its abatement is an offense that is punishable under this act. Exactly, contravention means you are not following the rules and regulations of this. It means also inconsistent. Attempt means to try and abatement means to instigate anyone. So whatever you will done, that is punishable offense. However, cognizance is required to be taken only on the receipt of complaint from appropriate authority, and only a metropolitan magistrate and judicial magistrate of first class have power to take cognizance. This is very important. Metropolitan magistrate and judicial magistrate of first class have authority, okay, under this act to take the cognizance of the offense. This is very important. The statute determined the adjudicating authority who may impose penalty. So who will impose penalty? Adjudicating authority if you are not following the rules and regulations of CAIIB Act. And you can also appeal to the appellant body. The appellant authority usually designated by the Central Board of RBI. That is important. The appellant authority designated by this one. Okay. Stay the enforcement of order passed by this subject to the terms and condition as it deemed. Dismiss the appeal. It means the appellant authority have a right to enforce the order, dismiss the appeal, and whatever they want. Okay, this is important. Now, the question is, appellant authority under the act is appointed by, tell me class, appointed by the appellant authority under this act is appointed by the RBI. Can honorary magistrate take cognizance? Right now we have just done that judicial magistrate of first class and metropolitan magistrate have a right. So in that case, the answer will be no. Every question is very important. So if you have really, revised all the concept now, you can easily do that, all the questions. Okay, now the next. The act is applicable to securities not in possession of the creditor. It means this act is applicable to security which is not in the possession of creditor. We have seen the list of security in which act is not applicable. Contravention of the provision of the act is punishable. Exactly, we know that if you do not follow the provision of CAIIB Act, it is punishable. Act has dealt with the stipulation for offense committed by the individual, partnership or company. If they do wrongful act, that is a punishable act. That is the punishable act. Okay. By debarring civil code, debarring means that the civil court have no authority. Debarring means civil court have no authority. So by debarring civil court or any other authority for jurisdiction for giving injunction, the implementation of act is made effective by removing the legal hindrance. Otherwise, the borrower can bring. We also have to see how and when the act has an overriding effect. Okay, next. The act has provided the provision of limitation act is applicable. Exactly, limitation act is also applicable. Central government has power to make rules for procedural implementation of the act, including directing that any of the provision of this act shall not apply to the class and classes of bank. Exactly. So this is totally the, the central government has the power that whether the central government can direct that SARFAESI Act will apply to this bank and will not apply to this bank. That is important one. Okay. The central registry has been set up and the provision relating to registration required under section this is applicable. The chapter also deals with the power of central government to remove difficulties that may arise while giving effect to the provision of the act. Okay. Now, for challenging action initiated by a secured creditor against the borrower can go civil court for injunction. Tell me, class. The borrower can go civil court for injunction. Right now we have done that is totally debarred to go to the civil court. So what is possible? That is totally false. Okay. Can a bank take action under SARFAESI against the deposit under lien, class? Just apply your concept, and we have read the SARFAESI Act is not apply to the various provision. So the lien is also there. So that apply to lien? The answer is no. Okay, hire purchase cover under the SARFAESI Act. Hire purchase. You can see how the question can be come from this one. The answer is totally no. Okay, after the bank notice, a defaulting party has paid within 60 days a substantial amount and the present dues are 15 lakh, which is 15% of the claim amount. Can the bank take a possession of the security? Tell me, class. The question is very simple. After bank notice, a defaulting borrower has paid within 60 days the substantial amount and the present due are 15 lakh, which is 15% of the claim amount. Can a bank proceed to take possession of the security? Yes or no? Which is 15% of the claim amount, 15%. And I think we have just read if it is less than 20%, SARFAESI Act is not applied. So that's why no is the right answer. Because you can see that second question, third question, fourth question is totally of your the SARFAESI Act, which is not applicable. So that is important one. Is that okay? Now, if some one point the provision of TP Act and SARFAESI Act is different, which act will prevail? If TP Act and SARFAESI Act is different on the same point, so which act is applicable? So we know that SARFAESI Act is applicable. Can a bank proceed to take possession of the security after 4 years of cause of action? 4 years. Sixth one. 4 years. The answer is totally no. Because 4 years is not the limitation. Within 3 years, you have to file the case. Okay. Provision of SARFAESI Act is applicable to the following goods. Pledge, Indian contract is there. Mortgage, TP Act is there. Security that is not otherwise charged. No, for unsecured that is not apply. 7th, security charged to the creditor and not in the possession of creditor. This is the right answer. D is the right answer. When do the rules framed by central government under the Act get valid? After Appellate Tribunal of DRT approved them, Supreme Court approving the same, immediately on framing the rules by government and notifying the same, or when the both House of Parliament approve the rules so framed? What is the right answer? The right answer for this question is class D. Everything we have just already read. Everything. Now this is your last chapter. So guys, we have just done the total 8 chapter of SURFACI Act that is given in your book. Okay, important one. Now, in this unit, we have to deal with the amendment of SURFACI Act in 2013 and 2016, which plugged the gap in the state you felt during the implementation over this one. These amendments were included in addition to Section 26, deal with the various issues as the ratification of error. Ratification means verification of error during the registration, priority to the secured creditor, registration of secured interest in the central registry, even in the case where there is a no secured creditor, conditions for this one. Okay, that is so simple. It is just about your amendment that is done in the 2016, in which various, offense and penalty provision has been done. Question. The central government may extend time for the registration of transaction of security interest and the securitization and asset reconstruction company modification for the maximum period of 30 days only. Extend the time for registration of transaction. 30 days only. That is right and wrong. That is totally false. Income Tax Department consider attaching the property in Jammu Kashmir belonging to X for recovery of tax dues. Is the attachment order required to file with the central registry? Because we know that the power of income tax officer is similarly same, so that's why this is the right answer. Where security interest upon property in the favor of secured creditor is filed for the purpose of registration, the claim of such secured creditor holding attachment shall have priority over any subsequent security interest created upon such property. That is true and false. Where the security interest upon property in the favor of secured creditor, right? Secured creditor means bank or financial institution, are filed for the purpose of registration, the claim of such secured creditor holding attachment order have the priority over the subsequent security interest. That is absolutely true. This is right. Recovery of tax by government department will have the priority even after registration of security interest by secured creditor. Recovery of taxes by government department will have the priority. Why should we give the priority? The answer is totally false. The answer is totally false, class.